Harani Law Circle மாணவர்கள் அனைவருக்கும் வணக்கம். I welcome you all back once again to our channel, and this is Advocate Frederick. This session is part 15 of our target to complete 50,000 multiple choice questions in law. If you haven't seen our previous 14 parts, I request you to visit our channel's playlist or check out for the links in the description box. These 50,000 questions will help you crack any legal examination which is conducted in your state or in the national level, be it the civil judge exam, special legal officer exam, judicial services exam, or even a district judge examination. You will have the confidence to put your 100% in your performance. These 50,000 questions are divided into 1,000 parts to make it easy and comfortable for you in your preparation. Having said that, our team has also planned for a mains-based descriptive question and answer series where I'll be covering around 1,000 mains-based descriptive questions along with answers and explanations, which will be very helpful for you in your preparation as well. So a comprehensive coverage of prelims, mains, and interview in our channel would obviously fulfill your dreams of becoming a judge. Having said that, I also want you all to subscribe to my channel so that you don't miss even a single part of the session. The only favor that I request from you is I want you all to share this session to your friends, juniors, if you are a professor or a teacher who is watching our session regularly, to your students as well. In that way, it will be very helpful for the students who are not able to afford for a proper coaching or to join a proper mock test. In that way, it will serve the society. So let's start with the first question of our session. When did the Code of Criminal Procedure 1973 come into force? So the questions will be basically in English and the explanations will be as follows. And the answers to the question are marked in bold so that you don't confuse with the answers. So the code came into force on the first day of April 1974. So the Code of Criminal Procedure 1973, which we usually call it as Act number 2 of 1974. Why do we call it Act number 2? So many students are not aware of it. Usually the president gives assent every year, right? So the first act that the president gives assent is called act number 1 of that particular year. And every year there will be some act number 1 of that particular year. And act number 1 of 1974 was in relation to an act with respect to the state of Meghalaya. And act number 2 was the Code of Criminal Procedure. And it was not immediately effected after the assent was given. It did not come into force. There was a central government notification which was issued, and the notice stated that the code would come into force on the first day of April 1974 to have a universal application on it. So, universal in the sense with respect to the whole of India, as mentioned in section 1, subsection 2 of the Code of Criminal Procedure. Previously, it was state of Jammu and Kashmir was exempted, but after the removal of special status for Jammu and Kashmir, the Jammu and Kashmir Reorganization Act of 2019 mandated or amended various acts and codes. So in that way, Jammu and Kashmir exemption was removed. Next one, what is the object of the Code of Criminal Procedure? To protect the innocent and punish the guilty, to protect the guilty, to punish the innocent, none of the above. So we all, by blindfoldedly reading it, we know that to punish the innocent would not be the object of any code or procedure. So it should be either to protect the innocent and punish the guilty or to punish the guilty. But looking at the code in its entirety, section 2 to section 484 of the code clearly gives you various procedures in its provisions of fair trial, investigation, the defense aspect, the right to be heard, and the constitution also under article 21 gives you various insights on fair trial, right? So we know that the protecting the innocent is also part and parcel of the procedure. So in that way, we have a dual objective under the Code of Criminal Procedure, which is to protect the innocent and to punish the guilty. So option A is the correct answer. Next, who enacted the Code of Criminal Procedure 1973? See, I am not skipping the question. I have already explained the question to you. And I don't think so there'd be a confusion with respect to the question. And if you need more clarity on what I said, just pause here and read the complete explanation and then move to the next question. Okay. And I'll also be giving you judicial observations and landmark decisions with respect to the concept. So I want you to focus on the explanations also. So don't skip the video and try to complete it and go with your own course of work. Just pause in the explanation part, read it, and then move to the next question. Don't be in a hurry to complete the video. Who enacted the Code of Criminal Procedure? 1973. State government, central government, state legislature, the parliament. So the Code of Criminal Procedure comes under the seventh schedule to the Constitution under list 3, which is the concurrent list, where the union as well as the state government can enact laws. The parliament as well as the state legislature can enact laws or amend any law with respect to the Code of Criminal Procedure. So Code of Criminal Procedure was basically enacted by the parliament, but the state has also powers to enact or amend any procedures with respect to its state or any part of the state. Next. Does the Code of Criminal Procedure 1973 extend to the whole of India? Yes. Previously, Jammu and Kashmir was exempted, but later on, after the Jammu and Kashmir Reorganization Act of 2019, now it extends to the whole of India. So the code was amended, complying with the rules act. Okay, but there is a special exception where the state government, by notification, can amend certain provisions so as to not apply to the state of Nagaland or to certain tribal areas with respect to a state, and certain chapters may not apply. Just read the explanation, you will have a better clarity. Next one. Is the Code of Criminal Procedure 1973 applicable to all the criminal proceedings in India? Yes, no. So the answer is no. Final year students or students who are bluntly reading law might think that criminal procedure applies to all criminal proceedings, but that is not the case. Section 5 of Criminal Procedural Code gives a clarity to it, where a saving clause has been given. The clause says that any special law or local law may override the provisions of the Code of Criminal Procedure, and such special or local laws may give a special procedure, and such laws should not be inconsistent with the Code of Criminal Procedure. So that is what it mandates. So there are laws which criminal procedures does not apply to those proceedings. Next one. In the Code of Criminal Procedure 1973, is it a general law? So you might come with a question to me that, sir, we don't expect such kind of questions like true or false, yes or no. See, I am not trying to give you questions which are directly asked in the examination. Most probably, most of our questions will be framed in such a way that you'll have those exact questions in the examinations, but certain questions are to help you remember and understand the concept in entirety. Okay, it is not just to put questions what is asked in the exam. It is to make you understand the concept with clarity. So these questions may be asked as part of your statements, and you might need to choose the correct or incorrect statements. So in that way, it will be helpful, obviously, right? So the Code of Criminal Procedure is a general law. It is true. So why is it a general law? Because it provides the basic and uniform procedure to be followed in all criminal cases like investigation, trial, appeal, execution of sentences, and it also applies across India to the whole of India. Next, can a state government make required amendments to the Code of Criminal Procedure? Already discussed, yes. Next one, can the application of the provisions of the Code of Criminal Procedure be extended to quasi-criminal cases? Now we have a new question, right? Quasi-criminal cases. So you might not have come across these terms. So quasi-criminal cases, obviously the code applies. What is quasi-criminal cases then? So it is called not strictly criminal cases, where there can be penal consequences which are involved, and the penal consequences may not be incriminating, or it is not a capital punishment, or punishments which are very less, like fine, penalty, or simple imprisonment. So these kinds of punishments with respect to criminal offences are called quasi-criminal in nature. Examples of such quasi-criminal cases are contempt of court, breach of maintenance orders under section 125 of Cr.P.C, or any other proceeding under taxation or municipal laws, or any other summary trials, okay, under any special acts. So these can be called as quasi-criminal cases. So the code applies there also. So this is mentioned in section 4. What is the meaning of bailable? So we have three sentences and we have option B as A and B. So A and B is right. Let's look at all the three sentences to understand it better. It means an offense which is shown as a bailable offense in the first schedule, or which is made bailable by any other law enforcement. So the first schedule to the Code of Criminal Procedure mentions certain offences as bailable and non-bailable. So there are only two categories. One is bailable and the other is non-bailable. And the first schedule mentions certain offences as bailable. So those offences are bailable. Point 1 is right. Next one, which is made bailable by any other law enforcement. So any other special law or local law may mention that as a particular offence as a bailable offence. Then those laws are also bailable offences. Option B, in bailable offences, the bail is a right of the accused. Obviously, yes. Option C, in bailable offences, the bail is not a right of the accused. See, option B and C are extreme opposites. So either of the one should be wrong. If B is correct, then obviously C should be wrong. The correct statement should be, in non-bailable offences, the bail is not a right of the accused. And option A and B are right. Moving ahead to the next question. What is the meaning of non-bailable offense? All the above. So let's understand what is non-bailable offense first. So it means any other offense other than bailable. So I told you that the first schedule mentions under the Code of Criminal Procedure only two categories, bailable and non-bailable. Any offense other than bailable are non-bailable. Okay. In non-bailable offenses, the bail is not a right. Yes. As we saw in the previous statement, I corrected it right. Option C. Next one. The bail is the discretion of the court. Obviously, it is not a matter of right of the accused, but it is upon the discretion of the court. He can grant bail in cases of non-bailable offences also. All the above are right. Just pause here and read the explanation in case you are not clear with it. What is the meaning of a charge? So the definition of charge is mentioned in the definition clauses, and the contents of charge are mentioned in section 212. And I'll explain you each of the contents in detail in the explanation part. Okay. So let's read through the options. Option A, it includes any head of charge when the charge contains more than one head. So this is the definition that is given in the definition clause of section 2 as charge, and contents of charge are mentioned in section 211. It is a open direct question. Charge means a charge sheet. No, charge does not mean a charge sheet. So option A and B are right. So let's look at the sections. Section 2B of Cr.P.C defines what is a charge, and option A was the definition to charge, which is the head of charge when the charge contains more heads than one. And section 211 Cr.P.C mentions what are the contents of a charge, and the first content should be, every charge shall state the offense with which the accused is charged. For example, if the offense is theft, the word theft should be mentioned, or what offense did he commit, the actions or the cause of action should be mentioned. Those statements are known as charge. Second one, if the offense has been given a specific name, for example, theft, murder, rape, dacoity, criminal conspiracy, those terms should be mentioned. The specific name given to such acts should be mentioned. The third point, The law and the section of the law against which the offence is said to have been committed shall be mentioned. For example, if it is IPC, IPC should be mentioned and the corresponding section in the IPC with respect to the offence should be mentioned. If it is any other law other than IPC, for example, Negotiable Instruments Act or any other law, Dishonor of National Symbols Act, so that act along with the corresponding section should be mentioned in the charge. Next, the charge must contain such particulars as to the time, place, and person to give the accused reasonable notice of the matter charged. So the accused person should need to know for what offense, for what, under what section, and the time, the place, and the person to whom the offense was committed, the victim needs to be mentioned. So it will give a reasonable opportunity for him to act upon such offense or accusation. Next one. What is meant by a cognizable offense? It means the police officer cannot arrest without warrant. Police officer has to investigate the case with the permission of the magistrate. The police officer may arrest without warrants. So in cases where grievous injury or an offense of murder or an offense of rape, which is bluntly can be proved is committed, then the police officer may arrest him without any warrant. He need not request the permission of the magistrate. Option C is the correct answer. So section 2 clause C of CRPC mentions what is a cognizable offense, where it means an offense for which a police officer may arrest without a warrant in accordance with the first schedule or under any other law for the time being in force. So the first schedule mentions what is a cognizable offense and what non-cognizable offenses are. So any offense with respect to cognizable cases, the police officer may arrest him without a warrant of the magistrate. 13th question. What is a complaint? Complaint must be in writing. Complaint must be in oral. Complaint may be oral or in writing. Complaint means police report. See, complaint is not police report. Complaint is something which is made to the magistrate and it is made only to the magistrate by the complainant. Okay. Sometimes the police may also be considered as a complainant, but complaint does not mean a police report. Police report are reports which are given by the police to the magistrate or to the court after the investigation has been done by the police. On the completion of the investigation, a police report is prepared by the police. So police report is not a complaint. Complaint must be oral, complaint must be in writing. So extreme statements like must should be obviously removed, but in law usually we have extreme statements most probably correct in various aspects, because in law we have statements like should. So these statements are extreme statements which are in most probable cases correct, but here complaint may be oral or in writing. So don't go for those extreme statement elimination. Don't go for that elimination trick in law papers. Don't go for that. So those those elimination tricks are most probably used in other exams like UPSC. But even right now, UPSC don't ask questions involving elimination tricks. They are very clear on that. Just study it very clearly. Don't confuse yourself. Section 2, clause D of CRPC defines a complaint. A complaint means any allegation which is made orally or in writing. So it is basically an allegation. It is made only to the magistrate. Next. Then you might come to me with a question, then what is that complaint that we go and give it to the police? So that is the information that we will give to the police. So that is why we generally call it as the first information report, FIR, right? So we call it as FIR. It is an information that we give to the police. It is not a complaint. Complaint is some allegation that you give to the magistrate only. Next one. Agreed person may orally complain to the magistrate. Yes, no. The answer is yes. So the aggrieved person may orally complain. Next one. To whom complaint can be given? Can it be given to the officer in charge of the police station? For example, a circle inspector or a sub inspector? No. Can it be given to the superintendent of police? No. Can it be given to any police officer? No. It can be given only to a magistrate. Complaint to be given only to a magistrate. When can the police officer be treated as a complainant? Now, police officers are also sometimes treated as a complainant. That is when, after the investigation has been over and the police officer discloses that a commission of an offense of a non-cognizable nature offense has been committed, the police officer prepares a police report and he gives it to the magistrate. Such reports are complaints, right? Next one. In a report made by a police officer after investigation, if it discloses the commission of a non-cognizable offense, can it be called as a complainant? Can he be called as a complainant? Yes. So the previous question and the present question are the same, but I have literally changed the words of the question so as to help you understand what it is. Just read the explanation. We have already seen it. What is meant by High Court? It means the highest court in the country in relation to any state, the High Court for that state, in relation to the union territory to which the jurisdiction of the High Court for a state has been extended by law, that High Court. See, High Court does not mean the highest court of the country. Supreme Court means the highest court of the country. You eliminate A, B and C are right. Next one. What is meant by India? India means the whole of India, including Jammu and Kashmir. It means the territories to which this code extends. India means the whole India, including Andhra Pradesh. So option A is obviously right, wrong. Option A, because India means the whole of India, including Jammu and Kashmir. So India means the whole of India, including Jammu and Kashmir. But we have more specific definition. India means the whole of India, including Jammu and Kashmir, yes. But that term doesn't mean India. India means even the territories to which this code extends. Wherever this code extends, that means India according to the code. Next one. What is the meaning of inquiry? Inquiry means the inquiry which was conducted by the police. Inquiry means which is conducted at the time of inquest. It means every inquiry other than trial conducted by a magistrate or court. So option C is the correct answer. Inquiry means every inquiry other than the trial conducted by a magistrate or a court. So section 2G of CRPC defines an inquiry. It means every inquiry other than a trial conducted by a magistrate or court of justice. Can a private person conduct investigation? Yes, he can conduct investigation if he is authorized by a magistrate. Section 202 subsection 1 of CRPC empowers a magistrate after receiving a complaint and before issuing process to direct an investigation or inquiry. The line under section 202 subsection 1, it states that a police officer may be directed with an investigation or by such other person as he thinks fit. So the magistrate may in his own discretion think fit any other person competent. The magistrate may, if he has sufficient ground for proceeding the case, direct any other person also. So this any other person, right? Next one. Investigation means arrest of a person, collection of an evidence, visiting the spot, all of the above. So all the statements are right. When you investigate, the police officer can or any other person directed by the magistrate can arrest the person, collect evidence, visit the spot. Next one. And adding on to the options, visiting the crime scene, collecting physical or documentary evidence, interrogating witnesses and suspects, conducting searches and seizures, arresting the suspects if needed, recording statements under section 161 and 164 CRPC are also part and parcel of investigation. See, section 161 and 164 4 will be dealt in the later part of our sessions. I am trying to complete Code of Criminal Procedure in order, so I don't want to confuse with these sections right now. Next, what is meant by judicial proceedings? The correct answer is A and B. Judicial proceedings include any proceeding in the course of which evidence is legally taken on oath or evidence may be legally taken on oath. So both the statements are correct. So your key point here should be, the point which you need to remember is evidence which is, evidence which may. So both is and may, both are correct. Next one. What is meant by judicial proceedings? So the first statement, as we saw in the previous question, is given here. So option A is right. Section 2I defines what is a judicial proceedings. Question number 25. What is meant by metropolitan area? So the area which is declared under section 8 to be a metropolitan area, yes. The town which exceeds the population of 1 million, yes. The state government can form a metropolitan area. All the above are right. So a metropolitan area is defined under section 8 of the Code of Criminal Procedure. The state government may, with the concurrence of the central government, declare any area comprising a city or a town with a population of more than 1 million as a metropolitan area for the purposes of the Code of Criminal Procedure. Next one. What is an offense? So any act or omission punishable by law is an offense. So offense is mentioned in the Code of Criminal Procedure under section 2N, where it means any act or omission made punishable by law any for the time being in force. Next one. Who is an officer in charge of a police station? So is it a constable, sub-inspector, constable, head constable? So the officer in charge of a police station is any police officer above the rank of a constable. Okay. So from the sub-inspector, the ascending hierarchy from the sub-inspector is a person who is the officer in charge of a police station. So it is only in the absence of the officer in charge of the police station, any other officer may be the officer in charge of the police station. Next one. 28. Place means a house only, any place, vehicle only. So a house, a place can include a house, building, a tent, a vehicle, or a vessel. So vessel means any ship or any cruise or any boat or any steamer which sails on the sea or which sails on a lake or which sails on a stream or which sails on a river or which sails on an ocean. All these are called vessels. So place means any of these, not limited to any particular thing. Okay. Next one. Who is a pleader? A person authorized by or under any law enforced to practice in such court. Any other person appointed by the permission with the permission of the court to act in such proceedings. So both A and B are right. So a pleader can be a person who is authorized by or under any law enforced to practice in such courts. For example, he can be an advocate having enrolled in the bar council of the state, or he can be any other person who is appointed with the permission of the court to act in such proceedings. So a private person can go file in the court for pleading for himself and he can plead for himself. So the court gives the permission for that other person to plead for himself, right? So both A and B are correct. Next one. What is meant by police report? It means a charge sheet. It means a final report, a report forwarded by a police officer to a magistrate under section 173, subsection 2 of CRPC. So option C is the correct answer. So police report is a report which the police officer gives to the magistrate under section 173, subsection 2 of CRPC. So when is this police report submitted is, it is basically, it refers to the investigation. On the completion of the investigation, the police prepares a report based on the investigation, and there is a prescribed format which the state government gives to the police. So he has to prepare on that prescribed format and give it to the magistrate concerned. Next one. What is a police station? Any place declared by the state government to be a police station, a building where a police station is located, a vehicle which is declared by the state government to be a police station. So option A and C are right. Any place declared by the state government to be a police station are police stations. For example, a building where there was a building which was usually called as a police station in a particular area, and due to renovation work, the police officials, along with the files and along with all other weapons and everything, is now transferred to another building which is nearby, which is a community service hall, and there are partitions to that particular community service hall, and that particular place is now a police station as declared by the state government. Then that place is also a police station now. It is not necessary that a building needs to be called a police station to be a police station. It can be any building where the state government declares that to be a police station. And it can also be any other vehicle that the state government declares to be a police station. So police station can be mobile and can be stationary as well. That is what we come to the conclusion from this question. It can be mobile. For example, a jeep which is standing in one corner of a junction can be a police station if it is declared by the state government to be a police station. Who is a public prosecutor? Any person who is appointed under section 24 is a public prosecutor. Yes, true. Any person acting under the directions of the public prosecutor is a public prosecutor. Obviously, both the statements are right. Inspector of police is not a public prosecutor. So section 24 of Cr.P.C deals with the appointment of a public prosecutors and additional public prosecutors and special public prosecutors by the central or state governments. So it includes persons acting under the directions of the public prosecutors, for example, an assistant public prosecutor or any other legally authorized person aiding the public prosecutor in a case. So they are also called as public prosecutors. What is meant by summons case? Not being a warrant case. So there are two categories, summons and warrant case. Any other category which does not come under a warrant case are summons case. Simple. It is like bailable and non-bailable. Any other offences which are not bailable are non-bailable. Next one. In summons case, maximum imprisonment should not be more than 2 years. It is right. So you cannot imprison a person in a summons case for more than 2 years. Section 2W of Code of Criminal Procedure defines what is a summons case. It is a case which is not being a warrant case, as we saw in the previous question. A warrant case is defined under section 2 clause X, where one offense is punishable with death, imprisonment for life, or imprisonment for a term exceeding 2 years. So imprisonments exceeding 2 years, imprisonment for life, and death are warrant cases, and any punishment, imprisonment which is less than 2 years are summons case. For example, fines, imprisonments for up to 2 years, all are summons cases. So warrant cases means a case where imprisonments exceed 2 years. It can also be life imprisonment and death, which are capital punishments. Next one. Can offences under any other law be investigated with the provisions of this code? Can any other law, for example, there is an offence which was committed with respect to Negotiable Instruments Act. Can the procedure under the Code of Criminal Procedure followed with respect to that particular law That is the question given. So it cannot be investigated is wrong. It can be investigated in the absence of special provisions to the contrary. For example, Negotiable Instruments Act specifically provide for a special procedure with respect to the offense committed. Then that particular procedure needs to be followed. If there is an absence in the special provisions or in the act, then the code of criminal procedure can be followed. It can be investigated. Next. Which act has to be taken for the meaning of a word and expression used in the code but not defined in the code? So in case a word or expression is not defined in the code of criminal procedure, then the definition as to the General Clauses Act can be taken as the definition. So that is what this question says. So nothing to elaborate. So if you need to understand the sections and other points with respect to this question, just pause here and read it completely. What is to be understood by the term magistrate when any reference is made in the code to a magistrate without any qualifying word? So in relation to a metropolitan area, it should be understood as to metropolitan magistrate. In relation to an area outside the metropolitan area, it should be understood as a judicial first class magistrate. For example, in cities like Chennai, in cities like Mumbai, in cities like Bangalore, or in cities like Delhi, Calcutta. So these are metropolitan areas, right? So metropolitan areas, the magistrate's qualifying word would be a metropolitan magistrate. And in cases where the area is area which is not a metropolitan area, for example, Salem is not a metropolitan area, then the magistrate in the area is called a judicial first class magistrate, judicial third class magistrate. Do you get the point? Next one. What is to be understood when any reference is made to a magistrate of the first class in relation to a metropolitan area? So a person who is a magistrate in the metropolitan area, then he is to be referred as metropolitan magistrate. So it should be construed as a metropolitan magistrate. Next. What is to be understood when any reference is to be made to a magistrate of second class in relation to the metropolitan area? So a magistrate of second class in a metropolitan area should be referred to as a metropolitan magistrate. So a metropolitan magistrate, the term is a wider term which includes metropolitan magistrate of first class and second class. Next one. What is to be understood when any reference is to be made to the chief judicial magistrate in a metropolitan area? So he is called as a chief metropolitan magistrate. In case if it is an area outside the metropolitan area, he is called a chief judicial magistrate. He is not called a chief metropolitan magistrate. He is called a chief judicial magistrate. Next one. Who can exercise the functions of a magistrate under any other law relating to custody, investigation, or trial, etc.? So the correct answer is option A. They can be exercised by a judicial magistrate subject to the provisions of the CRPC. Next one. I move to the next question because it is not that difficult for you to understand on reading the legal explanation. So here I want you to read it and move to the next question. I'm not explaining certain things because it is bluntly easy for you to understand. If you don't understand, just tell me in the comment section that you don't understand a particular provision or a particular question, and I'll repeat the same question in my subsequent videos so that you watch it and understand it better. As I have time constraints and I am also involved in various other cases in the high courts here in Madras, and I have certain other works to do, so I won't be able to put better time on explaining in detail. If you see, simple provisions are not a matter in your exams, and I streamline questions with respect to its importance also. If I leave it bluntly to you, then it is not much important, but I want to cover it as well. I don't want to leave it because in case if it comes in your exam, I don't want you to miss that 1 mark. So that is the reason I put those questions. So in case a question is asked on this will be the question. If something is asked on this particular section, this will be the question. So you have the question on the screen, you have the answer on the screen. So you need not worry about the explanation. That is what my point is. If you need to understand it better, just read the explanations. Who can exercise the function of a magistrate under any other law relating to granting of a license, the suspension or cancelling of a license? So who can exercise the functions of a magistrate? So the correct answer is option B. They can be exercised by executive magistrate subject to the provisions of CRPC. So granting of a license, suspending or cancelling a license, in cases where any other law relates, the function of a magistrate can be performed by an executive magistrate also. All offences under the Indian Penal Code shall be investigated, inquired into, tried, and otherwise dealt with according to the provisions of. So, any investigation, inquiry, trial, or anything with respect to the Indian Penal Code is with respect to the Code of Criminal Procedure. Next. All offences under any other law shall be investigated, inquired into, tried, and otherwise dealt with according to the provisions of. In case of IPC, it is Code of Criminal Procedure, as we saw in the previous question. In case of any other law, then is it the Code of Criminal Procedure? Not so. It is the Code of Criminal Procedure in case the special provisions or the special law has an absence with respect to the procedure, then the code applies. If the special law provides for a special procedure, then that particular procedure applies. Option A is the correct answer. 46. Can the provisions of CRPC affect any procedure prescribed in special or local laws in force? No, right? So only in the absence of any special provisions to the contrary, CRPC applies. Otherwise, the special law or local laws procedure is in force. Next one. Are the provisions of the code applicable to offences committed under emergency legislations? No. So the provisions of the code does not apply to offences which are committed under the emergency legislations. Next one. Is the Juvenile Justice Care and Protection of Children Act 2000 a special law in comparison with the general provisions of CRPC? Yes, it is a special law. So in case there is a special procedure which needs to be followed with respect to juvenile justice, then that special law procedure applies. If there is an absence in the procedure, then CRPC. Next one. High Court is also a criminal court. So in cases of an appeal, the High Court can also deal with matters, right? Who can alter the limits or the number of sessions, divisions, and districts? High Court, state government, the state government after consultation with the High Court. So the state government after consultation with the High Court can alter the limits or the number of sessions, divisions, and districts of any area. So section 9 of the Criminal Procedure Code states that the state government has the power to alter the limits or the number of sessions, divisions, and districts. However, such alteration must be done after consultation with the High Court of the state. So this consultation ensures that judicial administration is coordinated and efficient. So the High Court's views are important because it oversees the court's functions in those divisions and districts. So coming to the last part of the session, homework question. Who can form the metropolitan area? The state government, the High Court, state government after consultation with the High Court, the central government. So the correct answer to this question is the state government can form a metropolitan area. So with that, I end part 15 of 50,000 multiple choice question series from 701 to 750. See you in the next interactive session, part 16. Until then, stay tuned.